All right, we are back again. Welcome, everyone. The Community Action Partnership has a grant from the Office of Community Services to develop and manage the National Risk Mitigation and Quality Improvement TNTA Center, more simply known as the National Training Center. We've worked with CapLaw on this project through that grant. All of our previous recordings and slides are up on the TNTA Resource Center website in the Resource Bank, including the recording from Tuesday's presentation, part 1 of this series, as well as the slides from both part 1 and today's that we are about to go through. If you have any questions about that, please do find me in the chat window so we can direct you towards those. To start off today, we are going to do a little bit of technical information. You should be able to hear me out of your computer speakers. If you have any audio issues, you can restart the audio feed by going to the Communicate menu at the top of the screen and join audio conference to restart that. We are going to do, like on Tuesday, the hypothetical situations where we will be asking you for input. If you would like to do so verbally, if you could please go up to that Communicate tab and join the teleconference, which will give you 3 pieces of information: a telephone number, an event ID, and your attendee ID. If you put all 3 of those into your phone, you will be able to join us through the telephone and then use the Raise Your Hand feature to let us know that you would like to be unmuted. You can also submit comments during that time through the chat window, and we will read them out. We will do the bulk of the questions at the end. We have an hour and a half today, so there should be plenty of time for questions and feedback. You can send them in through the Q&A box at any point in time, however. There will be some polls that will pop up on the right-hand side of your screen. We do appreciate your participation in those. If you do send verbal comments in that you would like to be read out, if you could please send them to both the host and panelists. That will be an option on your chat window to make sure that they are in fact seen by all parties. So with that, I'm actually going to hand it over to CapLaw to get us started today.
Thanks, Cashin. Good afternoon again, everyone, and to those of you on the West Coast, good morning. This is Anita Lischblau with CapLaw, as the former director of CapLaw, and with me is Michael Shepsis, who is a staff attorney with CapLaw as well. I know that most of you were on the webinar on Tuesday, so we won't spend too much time going over part 1, and as Cashin mentioned, there already is available on the CAP website an archived audio version of the part 1 of this webinar from Tuesday. But just so that we can all be on the same page in terms of what we covered from part 1, there were a couple things. We did cover A110, obviously, and the sections that we covered were the super circular, the future of A110, standards for financial management systems, period of availability of funds, codes of conduct, and monitoring and reporting. So what we're going to cover today is a little bit more on, why does this all matter? Why should we care about this stuff? We already did the recap of webinar part 1. And then how does the circular apply to the following areas? And we're going to briefly talk about competition and procurement, prior approval, subawards, cost sharing, record retention, and equipment. So let's talk a little bit about what are the consequences and why should this matter. To be honest, some of this stuff sounds pretty dry. And so let's think about what the consequences can be if you do not meet some of these requirements. Obviously, one is termination of your grant, termination of your status as a grantee for Head Start, for example, or for CSBG. So those are potential, obviously, very long-term consequences. Also, a little bit less severe, but financially could be very problematic, is a disallowance of grant funds. You might have already spent them. You may now owe them back, or it may have to be taken off your next grant, or perhaps it won't be paid to you as a reimbursement. So disallowance of costs. For Head Start grants, if you fail to meet procurement, match, or other requirements, it can trigger a deficiency finding. And competition. And as we know, that's a very real consequence that has already happened to a number of CAPs, and some of those deficiencies have been in the area of administrative grant requirements. For example, failure to meet the standards for financial management systems. The states also often incorporate 2 CFR Part 215 by reference in their CSBG contracts with community action agencies. So a deficiency in that area might lead to a termination of the CSBG grant. And all of the issues that we talked about really on Tuesday in terms of safeguarding assets, tracking inventory, and so forth, those requirements must be met. And there may be more, of course, as well. The state may add their own requirements as long as they're not inconsistent with the CSBG Act. Okay, sorry, we reversed the order there. We already talked about this. And just to remind you, what we're talking about here is sort of taken off our guide that has just been published and will be put up on the CAP website and the CAP Law website, hopefully in a day or two. And that is the Spotlight on Nonprofit Grants Administration. Just real briefly, and Michael talked about this on Tuesday, but this is an annotated guide to A110, and it is based on real live situations that have been incorporated into decisions from the administrative agencies that interpret these rules, court decisions, and audits. And so what we've tried to do is take these rules and bring them to life by showing how they are applied in specific factual situations. So let's take a closer look at the rules, as we did last on Tuesday, by considering some hypotheticals. So as we did last time, I'll just read them, and then we will give you a minute or two to think about them and hopefully to either comment on them via chat or else you can raise your hand, so to speak, and Cashin will then unmute your audio line if you have called in on your audio line. So we are looking for participation. On Tuesday we did get quite a bit of participation, and we thank you for that, and hopefully that will continue. So what issues or problems arise out of the following facts? A community action agency outsourced its IT needs, its information technology needs, to a local IT contractor. The contractor was selected because most of the CAP's computers are Apple Mac computers, and the procurement manager had heard that the IT contractor specializes in Apple and Mac computers. That's pretty much what we know. Any issues or problems that arise out of those facts as we know them.
And again, while you do take a moment to think about this, you can put in through the chat window or the Q&A box, and we will read them out loud. We do not have very many of you on the phone, but if you will get our attention, we will be glad to unmute you. All right, we do have a couple of comments coming in, so we'll go ahead and read those out while you guys keep them coming. For one, there was no note, let's see, get this correct here. They needed to follow agency procurement policies and procedures to get the best results and give opportunity for other firms to apply. And we also have another couple of notes is whether there was time for others to bid or get other quotes.
Okay. Any others so far?
Mostly along the procurement policies themselves. They thought that there should have been a more thorough procurement process to ensure that other vendors who could have done similar tasks were solicited.
Okay, and I think
I have one more that I wanted to add in real quick, though. Someone did note that they needed to think about debarment status.
Okay, good. Those are all great points. And, you know, we'll talk in a minute about some of the more specifics on a procurement, but I think the basic point here is that this was done in a way too casual method, and that we don't know exactly in this hypothetical what their policies were or whether they were followed. But, you know, especially if you think about the importance of an IT contractor, that's just so critical these days, and you can't just be making these decisions on the fly. So that's sort of a general idea, but more specifically in terms of A110, this would certainly be subject to the requirement that there be competition, and so far here we didn't see any. I mean, there's some sort of very vague idea that this company knows what they're talking about because they specialize in Apple and Macs, but as someone said, this is most likely, you know, a fairly large contract. Depends on how much IT they have, but it's, you know, it's probably not just $1,000, $2,000. It's probably fairly significant, and so there should be some sort of bidding, calling, or either a more formal process, or else just making inquiries and asking other companies to bid on it, or to at least to research other companies and see what they do, what they charge, and so forth, and to document that. As someone said, also debarment is important. We talked a little bit about that the first session, and you know, at some point along the way, before a contract is signed, there should be an assurance that this contractor is not debarred. It should be checked on sam.gov, and perhaps a certificate signed by the contractor to ensure that neither the contractor nor its principals are debarred from doing business with federal funds or with the federal government. So this was definitely sort of a real bare bones type of procurement that, assuming that federal funds are involved, and I would assume there were, would probably not meet those standards. Okay. All right, so now we're going to go to the polling question. When selecting vendors for a federal grant program, the grant recipient must select the bid or the offer that is the least costly. And is that true or false?
And that poll is open on the right side of your screen. I see a few of you are starting to get those answers in. It's a shorter question, so we only gave a minute total. You have about 40 more seconds or so to get those answers in. All right, just about 10 more seconds or so to get those answers in if you are in progress. And the poll is officially closing at this point. In a few moments, we will be able to display those results for you.
Okay, false. Certainly got the most responses, and that would be correct. You know, in some state governments, sometimes I know that is a requirement that it really has to be the low-cost bid, but that's not always the necessary result. Sometimes it is, but obviously they have to be qualified, and there may be a situation. Let's use an auditor as an example. You might get an auditor who comes in at the lowest bid, but perhaps that auditor really doesn't have experience in auditing government-funded entities. Well, you know, then they're not necessarily the best choice, even though they may be the lowest price. And obviously, I'm sure you have many more situations yourself. But that's certainly an important criteria, but not the only important criteria. All right, let's move on to some of the more specific rules that come out of A110 in terms of competition procurement. We talked about the first bullet there. Another thing to remember is to be alert to conflicts of interest and non-competitive practices among contractors. So, you know, you need to think about how are you going to ensure that there aren't any conflicts between your vendors and staff people or board people. And, sometimes it's hard to actually implement them. So one thing you might want to think about is when you are starting off with a new vendor, or maybe it's not even a new vendor, maybe you do this periodically, you ask vendors to disclose whether, in fact, they are, let's say, related to anyone who's on the staff or anyone who's on the board. And you ask them to sign certain certifications, just the way you may ask them to sign the debarment certificate. You would also ask them to sign something saying, are you related to, or you probably want to specify what the level of relationship is, brother, sister, spouse, et cetera. And so that way you have it on record as to whether they are or they're not. And sometimes some CAPs and not-profit entities also have it on the other end. They will ask board members. I've seen some situations where there will be a list of vendors, and every board member is given a list of all the vendors. And they are asked to go through it and say, okay, do you have any relationship, either business-wise or otherwise that you know of, with any of these vendors? Of course, there may be situations where a board member or staff member may not even realize that some relative has some business interest in a vendor. And obviously, you can't expect that at all times, but at least it gives you some idea of whether there are any conflicts. So that's one thing to just make sure you have a system in place so that you can find out what those conflicts of interest are. Obviously, if you've got a situation, and this is a dangerous situation, where you have somebody who's basically in charge of selecting a contractor or a consultant, and that person has some relationship, familiar relationship, let's say, or maybe a business relationship with the vendor, that's obviously the most critical and is not allowed by A110. By the section on the Code of Conduct. So that would not be allowed. If there is a conflict of interest, whoever on the inside has the conflict of interest cannot be involved in the selection of that contractor, the administration of the contract, and so forth. Although there could be someone who is not at all involved in administering that contract or selecting that contract and is still on the staff of your agency. Again, you just have to make sure that you are disclosing and people are aware of it and it's dealt with appropriately. Non-competitive practices among contractors as well. You have to think about the issue of whether there are gifts and that sort of thing that are above your threshold, or whether there are any contractors or vendors that are getting together and sort of antitrust violation issues there, and getting together and therefore making it difficult to get the best price. So that's another issue. You may not award contracts to contractors that develop or draft specifications, requirements, statements of work, and invitations for bids. So sometimes you'll see situations where that does happen, where it could be the same company that's developing the specifications and then they actually bid on the work. There's a clear conflict of interest there, so that's not allowed by A110. In selecting the bid, make sure that you're looking at the result or the vendor that has the best price, quality, and other factors considered. And you're also going to look at what is the reputation of this contractor or this consultant. So there's a number of different factors that you're going to look at. If you're doing an RFP process, of course, you should be clear and transparent in the RFP about what factors you are going to look at. And you should also kind of have a catch-all phrase at the end. So, you can sort of give yourself a little leeway if it turns out that you decide that this is not the right contractor and it's a little bit more nebulous reason why that's not the right contractor. So you do want to try to give the potential bidders, though, some idea of what they're going to be selected on, what the basis for selection is. Obviously, avoid purchase of unnecessary items. That's the kind of thing that auditors will come in or monitors will come in and say, did you really need that flat screen TV in the conference room, that type of thing. So, make sure it's necessary for the furtherance of the grant purpose. You're also required to seek procurement from small business, minority-owned firms, and women-run enterprises whenever possible. Many states, well, at least some states, have programs where there are, let's say, women-owned businesses that get certified as such, and you can get lists of those businesses from the state. So if you don't already have that, you should check with your state to see if there are such lists. If not, there may be an opportunity to do a little outreach to try to get more minority-owned businesses and so forth, small businesses into the loop in terms of doing business with you. So that's certainly one of the things that the government is also interested in. So these are not all of the particular issues, but they are certainly some of them. Okay, another issue is for real property, leasing costs. Rental price per square foot is something you should be looking at, obviously. Generally speaking, you are going to do a purchase versus rent analysis, but we did see one case where, in fact, they hadn't done a purchase versus rent analysis, and what the DAB said was that, well, it wasn't necessary because they wouldn't have had the funds to buy a property anyway, so it would have been sort of a useless exercise. You know, I'd be careful about relying on that unless you really could show that there's no way you could buy something, but that is what one DAB decision said. You should certainly seek more than one bid if possible, and you know, the if possible, obviously that's somewhat subjective, but I think that the default should be that there should be more than one bid sought, and only where you can document and establish that there's no way to get other bids would that be allowed, basically a sole source situation. And I think that should be in your policy. So, you know, we recommend that you set dollar threshold amounts for the number of bids. Perhaps over 5,000 you need 2, over 25,000 you need 3. I'm just giving those examples. They're not, don't quote me as set in stone, but whatever it is, be clear to the people out in the field as to what they need to do. And again, if you're going to go sole source, make sure you've got a real good reason and that you've actually tried and you've documented those attempts to find other bidders, either through an RFP process that's been well advertised, or if it wasn't an RFP process, you know, who did you call, who did you ask for quotes, where did you go? So those are all things that you should keep in mind. This is one of the areas where there may be some change, possibly if the proposed super circular that OMB has proposed a few months ago goes through. What they're proposing is something that's more akin to the procurement process required for state and local grantees. And so it's a bit more rigid, which may not be to some community action agencies' liking. On the other hand, some may like it because it's clearer. But in any event, it goes through more detail in terms of here's when you have to do sealed bids, here's when competitive proposals are enough, and here's when sole source is okay. So it goes through a more detailed and more prescriptive method of determining what type of procurement you can do in a particular situation. It also would require that any protest by vendors would be reported to the funding source, which again I believe is in the state and local grantee version of A110 now, but it's not in A110 itself. And the small purchase threshold would be raised to $150,000. And again, this is not yet in effect, and at this point we don't even know if it will be in effect because OMB did receive comments on their proposal, but they have not modified anything yet. So these are just things to think about, but these are not yet rules, nor they might never be rules. So particularly that second one, I think people have real problems with. I know when we comment on that, this whole idea of protest by vendors have to go to the funding source. You know, that seems a bit micromanagement to me. So hopefully they will get rid of that requirement. Let me just, one point on the $150,000. Some people may be a little confused and say, wait a minute, I thought it already was raised to $150,000. It was in the FAR, which is the Federal Acquisition Regulation, which applies to for-profit contractors, but that doesn't generally apply to grants. And so it wasn't actually, I won't go into all the details, but it really wasn't raised to $150,000 yet, although some granting sources, funding sources have been treating it as if it had. But I would say until you get more definite a rule change on this, I would keep it at $100,000, which is where it is now. And what that means is that if it's anything over $100,000, the government can come in and ask for documentation as to why, if you had sole source, why it was sole source, and ask for documentation of where the competitive proposals were over $100,000.
Okay, so here we have hypothetical number 2. What issues or problems arise out of the following? A CAP received a grant to create a construction company for purposes of generating jobs for low-income residents. The approved grant application called for the renovation of a specific building site. After reviewing the construction site, the CAP determined that renovating it would not be feasible. Therefore, the CAP contacted a for-profit commercial real estate manager and developer to alter one of the for-profit company's existing buildings for the grant project. The CAP gave control over running the program to the for-profit. At the end of the project, many low-income residents were hired for the created construction company. So why don't you take 1 minute or 2 minutes just to think this over and see what issues or problems you can come up with.
And of course, the same thing. If you are on the phone, you can raise your hand to let us know that you would like to be unmuted, or you can put your comments in through the chat or Q&A box. We did have a couple of questions that came in after the last hypothetical. I will not distract people while they're looking at this one, but we may want to come to those in a few minutes. All right, we do have several different comments coming in. We will see how, if Capwell is able to answer them. It sounds like they actually had a fire alarm in the building. Always an interesting day. But some of the things that people have started to come in with, subgranting and change in grant proposal approval was needed. And then kind of the question was approval obtained from the grantor for the change in scope. A CAA would need to request a modification to a subcontract. The CAA did not go back to a funding source for permission to make changes. So many along this line. Purposes outlined in the grant application and approved by funding source were deviated from without a prior approval.
Great, yeah, exactly, and those are the things we were looking for. So here we have a CAP that received a grant to create a construction company on a specific site. However, the CAP then went on to develop a different site. They also outsourced most of the project to a different entity, a for-profit entity here as well. And most of the control over the project was given to the for-profit company. So even though the ultimate goal of the project arguably was achieved, which was to create low-income jobs, all of these major decisions should have had prior approval from the funding source. And the general rule is that prior approval is needed to change the direction of a project, and it's also needed to redirect grant funds to a different entity or project.
And I just want to emphasize that last point, because even though maybe someone would have said, well, you know, at the end of the day, the issue was our low-income residents being hired for jobs. That was really the point of this. It doesn't really matter what entity. Well, it does matter what entity, because, you know, that may really determine what sort of safeguards there are of the assets and of the grant funds and so forth. And, you know, the more subcontracts and subawards there are and money going to different places without proper controls being in place, the less control there will be over whether the funds are used for the grant purposes. So particularly when it's going to another entity other than that which has been explicitly stated in the grant application, that's when you really get into trouble. I mean, I've seen some situations even that have ended up in criminal cases where CSBG funds, for example, were then used by an executive director and the deputy director to set up another company, and they funneled money through there, and then they took that money and bought supplies for home health services and then sold it back to the agency at a markup and so forth. So I think that funding sources are often very wary of situations where they see money being, as they think of it, sort of funneled back and forth.
All right. Looks like we're going to take a couple of questions that had come in previously. Is there a minimum contract amount where disbarment must be verified?
I believe that it is typically $25,000. Let me say that there's two different situations. One is where you're getting a direct grant from the federal government. Sorry about that. We think it's just a test, but we're checking that. And in those situations where it's a direct grant, you will probably get that certification form from, for example, HHS, and they will ask you as the grantee or as the applicant for the direct grant to sign it. What's a little trickier is when you are then contracting out for various things. At that point, typically it's $25,000, but sometimes the agency, the funding agency, can specify, for example, that all subcontracts have to be debarred. I find it's easier just from an administrative point of view, but this is up to you folks, to just do it for all of them because it just seems easier to just, as a matter of course, just send it out with all of your RFPs or all of your contracts and just get them all rather than having to have somebody differentiate between them. It's, you know, it's not really a big hassle for people to sign it as long as people sort of have a general understanding of what it is they're being asked to do.
All right, thank you. And we did have another one that came in. Is there an exception that when you offer a sealed bid that you must select a least costly vendor?
I don't believe there's any specific requirement for that. And you know, if you, first of all, if I'm assuming we're talking about nonprofit entities, there's certainly nothing in the A110 itself. But many states will have their own rules about how to actually conduct these sealed bids or these procurement processes. So I know there are some caps that, in my view, unfortunately, are subject to some state procurement rules. In other words, they're treated as if they were state agencies and have to follow the state agency procurement rules. And so if that's the case, I don't think that's true for very many, but I know it's true for a few, then you should be obviously intimately familiar with what those requirements are. But I think otherwise, you know, as long as you're transparent about what the process you're using is, I don't think you necessarily have to go with the lowest price even in that situation. All right, why don't we move on then to the next slide.
Okay, so now we have polling question number 2.
Which is open on everyone's screen on that right-hand side. We did give you a minute and a half since this one is a little bit longer. All right, just under a minute to get those answers in. Many of you have already started. Just for the benefit of those that catch us on the recording later, I'm going to read out the polling question. In which one of the following circumstances should approval from the funding source be obtained? That A, grantee decides to develop a different property from the one described in the grant application. B, the project director leaves her position to become a consultant to the project. C, grantee changes its name. D, two of the above. Or E, all of the above. And there are about 10 more seconds to get those answers in through the live poll here. All right, our poll is closed, and we have results.
Okay, and it looks like most people said all of the above. A few said two of the above. All of the above is actually the correct answer. So A, grantee decides to develop a different property from the one described in the grant application. Prior approval is needed for construction projects and for major changes in construction projects, such as deciding to develop a different site. B, project director leaves her position to become a consultant on the project. A change in key personnel does require prior approval, including in a situation like this where an individual might still stay on the project but now in a new capacity as a consultant. And also a grantee changes its name, C, that also requires prior approval because it's considered a restructuring change. So prior approval from the funding source is required for a change in the scope or objective of a grant program. It's also required for changes in key personnel or a major reduction of time to be spent on a project by a program director. And as we saw in the hypo, a change from regular staff to a consultant is considered a change in key personnel that requires prior approval. Prior approval is also needed if you need more federal money, and prior approval is required if budgeted indirect costs need to be transferred to direct costs or vice versa. Here are some more circumstances that require prior approval: major changes in construction plans, redirecting funds to an alternative project, redirecting funds to a subsidiary, also charging costs not described in the budget. So for instance, in one DAB decision, which involved a construction project, the grantee had listed project management cost as a cost. And later, it was allowed to charge personnel costs without obtaining prior approval because personnel costs were deemed to be a type of project management cost. However, on a different project, that grantee had failed to list project management, personnel, or administrative costs, and therefore it did need to obtain prior approval to charge certain personnel costs. Lastly, prior approval is needed to restructure your organization. This includes changing from a for-profit to a nonprofit, merging with another entity, or even changing your name. And also, it's very important that you remember to obtain prior approval in writing.
I just want to jump in here for a moment on the last bullet, restructuring organization. This has become an issue occasionally, but not that infrequently, especially with Head Start grantees, because they are very strict. The ACF is very strict about any sort of change, like a merger. They are probably going to say it has to be recompeted if it's a new entity. So if that's something that you are considering, any sort of structural reorganization, I suggest that you speak to your attorneys and speak to your regional office and make sure you understand what is going to be the consequence of doing that in terms of recompetition. That may factor into possibly how you want to restructure or if you want to restructure. I'm not saying you shouldn't do it, but you should just be aware that there may be that consequence if you do so.
Okay, so now let's revisit several words. We touched on these briefly on Tuesday's session. So with several words, remember, you must apply A110 to subrecipients that are institutions of higher education, hospitals, and nonprofits. OMB Circular A133 provides guidance on when a contract forms a subrecipient relationship and when it forms a contractor-vendor relationship. And as you can see in the slide, there are factors that will influence what type of relationship is created. Generally, the more control you give to another entity, the more likely you are to create a subaward. The reason the type of relationship that is formed makes a difference is because if you are dealing with a contractor, you must follow the procurement rules, such as open and free competition. On the other hand, if you are dealing with a subrecipient, you must make sure that your missions agree, you must make sure that cost principles are followed, and you receive prior approval from the funding source. So let's take a look at an example. Similar to the last hypothetical that we looked at, a CAP receives a grant to run a job training and placement program. The CAP outsources the actual training to a different organization. So will this form a contractor relationship or a subrecipient relationship? So if the training provider conducts outreach, determines client eligibility, provides training and placement, and conducts case management, this will likely be a subaward. If on the other hand, the grantee conducts most of these activities, but outsources the training on the weatherization of homes, for instance, this will likely be a procurement contract. So basically, the more the grantee outsources, the more likely it is to create a subrecipient relationship. Now let's take a look at hypothetical number 3. What issues or problems arise out of the following? A CAP receives a special Head Start fatherhood grant with a 10% match requirement. The CAP enlists several volunteers to teach throughout the year. One of the volunteers also offers legal consulting services pro bono. The CAP estimates that the fair market value of the services provided by the volunteers will total to the required match amount. At the end of the year, volunteers prepare and submit forms that report the hours volunteered and in what capacity. So let's take a minute or two just to look this over again and let us know what issues or problems you see here.
All right, thanks everybody. Keep doing what you have been doing, sending in those comments, and we will read them out and respond. We do have another question that we will handle after the hypothetical. We have several comments coming in, which is great, and actually on a variety of different topics related to this one. We have a couple of people talking about the regularity of the reports and should those be submitted more often than once a year or at the end of the year. We have a note about possible conflict of interest with the volunteer offering legal services. The estimates are not sufficient, that volunteer forms should report hours, capacity, and for the lawyer, the standard hourly billing rate at their firm. One that asks, do we even know if the match can be in kind or volunteer hours versus the money? and that the valuing of the time would be determined by fair market value of the service provided, so the teaching would be at one rate and legal services should be at another rate. And last but not least, coming in, the CAA should obtain wage and fringe information for the position in which the volunteers will be serving in order to value the match.
Great, yeah, most of those are actually what we were looking for. So here we have a grant with a match requirement, and as someone pointed out, there's the initial question of can the CAP contribute volunteer work to meet this requirement? In other words, is an in-kind or a soft match permissible? So the CAP would have to look at its grant to see if in-kind and soft matching is allowed.
And typically, I mean, certainly in the federal grants, it typically is allowed. So I would say I've seen some grants, usually state grants, where sometimes they'll specifically say it's not allowed, it has to be cash. But usually either one is allowable.
And then assuming that in-kind assuming the in-kind match is permissible, then documentation will be critical to support and to value this kind of match. So it's good that the CAP used timesheets here. However, and I believe someone pointed this out, the regularity of the timesheets is a big issue here. And really the timesheets should be prepared contemporaneously with the volunteer work performed. And it's also important to document what services were actually provided, as in what did the volunteers actually do. And you also want to document how did the services benefit the program.
Right, because a match is only good to the extent that it is something that would have been required for the program itself. In other words, something that you might have paid for if you had the funds to do so. So you can't have someone volunteering to do something that's really not necessary for the program to begin with. And that was something that back a few years ago, some of you may recall, with transportation, a lot of CAPs had been using parent time to take their kids to Head Start as match, and back a few years ago, Office of Head Start said no, because, well, I won't go into all the details of it, but basically because if they're driving their own cars, that's now no longer in compliance with the Head Start requirements, and so therefore we're not going to count it as match. But there might be other situations as well where you have to ask first. The first question is this something that is basically part of the grant, required by the grant? In other words, if we were spending grant money, would it be an allowable expense?
And then also in this hypo we have the volunteer that contributed legal consulting services. For professional services that are being contributed, you need additional documentation, and I believe that this was pointed out too. You want to document first, what is the ordinary fee that individual would have charged? And then you also want to document what's the ordinary market rate for such services in order to help value the match that's being contributed.
And it also obviously has to be the market rate for the services that are being contributed. So if you change that hypo a little bit and you had a lawyer that was painting, so obviously the value would not be his or her legal hourly rate, but would be a fair market value rate for a painter. And that was, I believe, one of the questions as well. It says you use fair market value versus standard rate for volunteer hours. I'm not quite sure I understand what the standard rate is. So if somebody wants to either get on the phone or chat a little further, I'm not quite sure what they mean by standard rate. But basically the rule is that you use fair market value. But maybe I'm not quite understanding that question. So you can follow it up if you want, whoever wrote that, and you can try to get at that a little bit more.
Okay, let's move on. So here we have polling question number 3. True or false, in determining the cost sharing match value of donated space in a building.
Oh, excuse me, can I just go back to one other comment
sure,
that
yes.
someone made? I don't want to forget. Someone also mentioned that you should include benefits, I believe, and in other words, not just
and
salary and fringe, yes.
Right.
And I think that is a good point. That, by the way, that's possible. That may change, maybe, in the proposed reform. We hope not. But that is a good point, is that you are allowed to include not only what the salary would have been, but what the fringe would have been. Sorry, Michael, didn't mean to interrupt.
No, that's a great point. I'm glad we covered that. So yes, polling question number 3. In determining the cost-sharing match value of donated space in a building, the grantee may rely on the report of an independent appraisal. True or false?
All right, this will be a fairly quick one on those answers, just because we had opened it before we went back there for a moment. Some of you had already gotten started. All right, so this will probably not be our best response rate, as we did distract you in the middle of that poll, but we will be able to get the answers up momentarily. And then before we move on to the next section, I did have one question that had come in prior. But here are your results.
Right, and so most of you said true. And yes, it's definitely true. It's actually more than just may, the grantee may. The grantee must. When determining the value of donated space, the grantee must obtain the report of an independent appraisal. And this is straight from section 215.23H of the rules.
Just one other point on that, just want to make sure people are clear on this, because it has caught up a few Head Start grantees recently, is that that's only for donated space. So in other words, if you or a related entity, the CAP or related entity, actually own the space, you cannot sort of charge the difference between, you cannot count as match the difference between what you're actually charging to the Head Start program and the fair market value. Even if you have an independent appraisal, generally you can't. There is a procedure, if you look in the rules, I won't get into that detail, where you can get prior approval under some situations to do that, but you cannot just do that as a matter of course. So if you're thinking of doing that, I would read the rule on that real carefully and see whether you qualify or want to get approval to do that. Generally speaking, the rule is no, you can't do that. Only for third-party donated space can you use it as match.
And I believe we had a question.
We did. They were asking, is there a need for prior approval regarding if a contractor's name changes?
If a contractor what?
Name change?
Oh, if a contractor changes their name.
No, I don't think so. I'm not aware of that. I don't believe so. Let me just clarify one point I just made before, because I don't want to confuse people. When I said that generally speaking you cannot use as match the value of space if you own the entity, let me be clear that what I meant is the fair market value. You certainly can use as match the cost, the value of the, not the value, but the cost that you actually put into it and that you have not already charged to the program. But you can only charge it or use as match up to the cost and not the difference between the cost and the fair market value.
Okay, I think we can move on. So as you can see here, cost sharing or matching is permissible where it is verifiable from the records, now already included as contributions for other federal programs, necessary and reasonable, allowable under the cost principles, not paid by another federal awarding agency, approved in the budget, and conforms to other provisions of the grant administrative requirements. And this is straight from the rule found in section 215.23.
Let me just weigh in here for a moment on the question of, is it not already included as contributions for other programs, or is it not paid by another federal awarding agency? Sometimes this has come up. Sometimes people think incorrectly that CSBG may actually be used for match and other programs such as Head Start. That is not the case. CDBG, Community Development Block Grant, I believe can in some instances be used for it. And there also is some confusion just about many of the HUD programs do require match. And there are HUD regulations that say that you can sometimes use other federal funds for match as long as it's not explicitly prohibited. This is a very this is a somewhat confusing area right now. We're trying to get clarification from Office of Community Services on those HUD programs. But I would say for now, the rule always has been that you cannot use CSBG money for match. And I would stick to that until you hear something, not just here, but you see something in writing by an authorized person that says to the contrary.
And then also, as we briefly discussed in the hypo, when considering cost sharing or matching, you may include volunteer services where services are integral and necessary and valued at rates for similar paid work, and also donated supplies, equipment, building, and land may qualify as a match. Also, as we discussed in the last hypo, documenting volunteer time should consist of, forms should be completely filled out. So if you're using a particular kind of form, make sure you do not leave sections that are blank. Forms should be completely filled out so as not to confuse the funding source. Forms should be prepared contemporaneously with the volunteer work performed. There should be a description of activities performed, and there should be a description of how activities performed actually benefited the program. Remember also that when documenting contributed professional services, like business consulting or legal services, you should also document what the professional would have charged for this work and what the services provided would typically have cost in the market. And this information will be used to determine the value of the match. Okay, so let's move on to hypothetical number 4. What issues or problems arise in the following? At the start of a federal award project, the executive director of a CAP hired her daughter for a bookkeeping position. The executive director's daughter remained employed on the project until its conclusion. 4 years after the conclusion of the project, and with no audits or other inquiries initiated by the government, the executive director destroyed all records kept during the grant except for the grant application. So please take a minute or two to look this over and give us your feedback.
All right, we do have the first comment or two coming in, so do keep those coming as you think about this. All right, we have several comments coming in. They kind of seem to fall under 3 camps for the most part so far. The biggest being that this is clearly a conflict of interest for the ED to be hiring the daughter. Another couple of notes on the records should have been kept longer than 4 years. Should have been kept 7 years also has come up. And someone else had, depending on the award, the fact that there were no single audits performed could in fact be an issue as well, in addition to the record retention and conflict of interest issues.
Okay, great. So yeah, clearly there's a potential family favoritism issue here with the hiring of the executive director's daughter. And we looked at actually a similar conflict of interest hypo in the first session that we did on Tuesday. So actually, let me just provide a little additional information here that doesn't appear in the hypo. This is actually based very closely to the facts in a real DAB decision called Utica Head Start Children and Families, DAB number 1749. Again, that's DAB number 1749. And in that decision, there were very similar facts. And what happened there was the executive director's daughter was hired for a bookkeeping position, and the CAP had claimed that ACF had actually provided a verbal waiver to the family favoritism rules. But again, just a verbal waiver. So here, yes, there's a 3-year general retention rule. But in this case, records should have been kept for longer, and that's what the DAB found as well. Here, there was a controversial hiring decision made, and even though no investigation was initiated within that 3-year period, because this was a controversial hiring decision, documents should have been retained that could justify that decision, especially since the CAP claimed that there was a verbal waiver, but I mean, who knows what really happened or what was said. It's also a good idea to keep personnel records even after employees leave. And regardless, it's always a good idea to keep certain records indefinitely. Here they kept the grant application, but it's also a good idea to keep the final grant report and the closeout letter. Now, someone had mentioned that records should have been kept for 7 years. I'm not actually familiar with that number.
That may be someone's getting that from perhaps the IRS, because this could be potentially a sort of IRS conflict of interest, intermediate sanctions perhaps. Maybe that's where they're getting it from, or certainly some states have a 7-year rule. So I'm not quite clear where that comes from. But I think a couple things. One is that whenever you get from the funding source some sort of waiver or exemption from the regular rule, of course it should have been in writing rather than an oral waiver. It was apparently the case here. But I would keep that, especially where the employee is still employed. In the Utica case, the daughter was hired as a bookkeeper but then became the CFO, if I recall correctly.
Right, or the fiscal director.
The fiscal director or something like that. So, I would think you should certainly keep for all of your employees while they are still employed by you those employment records. Not necessarily, every time card, every payroll, but, basic records, the hiring records, if there are any exemptions, conflict of interest, what their pay rates were over the course of their career with you. Those should be kept the whole time that they are employed by you, and a little bit longer as well. Sometimes, of course, someone will come back. Having been out for, maybe they leave for a couple of years, they come back. You don't have to, I don't think you have to keep all the records forever, but there are certainly some employment laws that will require that you keep things for a couple of years. We can't go into, we don't have the time to go into all the details of how long you should keep each one of the employment records even after they've left. But certainly while they're still employed there, you should be keeping all of those basic records relating to their employment, and certainly anything related to any kind of exemptions that have been given. One person asked about, I think, why there wasn't any independent audit. I don't think it says that there wasn't any independent audit. What this means here is that there was no audit or other inquiries initiated by the government. In other words, the government coming in and doing its own audit. I don't think it's necessarily the case. There probably were actually independent audits done in this case.
All right, we do have a question or two that have come in this section. Kind of a two-parter, I guess. How long after the 3 years should records be kept in a unique situation, and then are there any employment or payroll records that are required to be kept indefinitely?
Okay, well, in terms of how long should they be kept, it's a bit of a judgment call. If we're talking about, let's say, property records, maybe you've used federal funds to purchase a property, then those should be kept until, those should be kept basically forever. or until you've sold the property, because if there's going to be a federal interest in that. So you want to know how much money you, the CAP, has put into that property, because when it's sold, you're going to owe the government some money, and you want a record of how much you put into it versus, in other words, of your own CAP money versus how much federal funds were put into it. So you want to keep those records long after the end of the grant, assuming you still have that property. So property records should be kept until you no longer own the property and until all of those issues have been resolved with the funding agency. The same thing for grant closeout records. I mean, these days it's so easy to just to scan things in and put them in electronically. So, if you don't have the paper space, I would at least do that. We have seen situations occasionally where, this is actually OCS came in, I think 7 years after the fact. It was a state association grant, and they came in and said, excuse me, you owe us money. And, it was never closed out or something. And in fact, they didn't owe the money, but we had to help them with going through a lot of rigmarole because they no longer had the records because the 3 years had long passed. And it was very difficult to resolve this. Eventually, they were able to prove that they did not owe the government money, but if they'd kept the closeout records, it would have made it a lot easier. So some of those basic records, I think I would keep. The notice of grant award, the grant closeout records, and as I said, some of the basic records for any of your employees that are still employed by you, and as well as any kind of decisions, like written decisions or exemptions or something that have been given by the funding agency. I would keep that type of thing. I wouldn't keep the sort of daily records of the grant past much. I would keep it probably 4 years because I just think it's hard to keep track of when the 3 years end, because it's not 3 years from the end of the grant, it's 3 years from when the final report is submitted, and it's hard for people to kind of know when that is, at least people in the program level. So I just make it 4 years just to make it easy. In terms of employment records, how long those have to be kept, I think we'll have to leave that to a different time. If you want to email us, we can get you that information. There are a lot of different employment laws that all have sort of different rules. So I can't give that to you right off the top of my head, and it's a fairly lengthy rule. But just in general, it ranges from 1 year to, I think, with OSHA, sometimes 30 years. But we can get you more of that information if you email us offline.
Okay, let's move on now to polling question number 4. True or false? 3 years after the conclusion of a grant project, if no audits, investigations, or litigation has been raised in relation to the program, all grant documents may be disposed.
All right, that poll is open, one of our shorter questions, and we have just covered this topic a little bit, so you do have about 30 more seconds or so to get those answers in. All right, just a few more seconds if you have any last-minute button pushers here. And the poll is officially closing. We should be able to get you answers in just a few seconds.
Well, it looks like most of you said false. And I mean, this is a little tricky, although we covered it pretty much in the hypo. Although the rule technically says the record retention period is 3 years, really records should be kept for longer. It's good practice to retain records for 4 years, and like we said, there are certain records should be kept indefinitely, such as the grant application, the final grant report, and the closeout letter, also personnel records, and all the things we touched on.
We didn't mean personnel records don't have to be kept permanently for everybody, but certainly through the time that they are still employed by you. And in some circumstances, depending on what the law is, you may need to keep it for some period of time after that.
Right, exactly. So the general rule for record retention is 3 years from the date of submission of the final grant report. However, if an audit or an investigation or litigation is initiated, this will expand the 3-year period. Documents relating to property and equipment should be retained for 3 years after the final disposition of the property or equipment. You should also keep in mind that the funding source may request access to records and employees. Also, when retaining contracts, remember to retain a copy of the actual fully executed contract and not just a copy with the terms of the contract.
And we've seen that get some folks into trouble. I think it was a weatherization contract. There were a bunch of contracts, but a lot of them weren't signed by both parties, and the monitor was very, very picky and said, sorry, we're going to disallow those costs because you don't have a contract that's fully executed.
Right, and also in the proposed super circular, electronic records would be permissible.
Okay, so now we're going to go on to the final polling question, number 5. How often must inventory of equipment be conducted? A, once a year, B, twice a year, C, once every 2 years, D, once every 3 years. Give you a minute.
All right, you do have 1 more minute to get those answers in. If it looks like we have most of those in, we can stop a few seconds early. The poll does have about 30 more seconds on there. If there were any others that were trying to get answers in, it looks like our activity has kind of come to a slowdown, so we probably will go ahead and close the poll a few seconds early. All right, we are closed. And results.
Okay, so it looks like the largest number went for once every 2 years, but a fairly large number also said once a year. The correct answer in terms of the requirement is once every 2 years, although obviously if your policy is to do it once every year, that's fine too, but you need to make sure you're in compliance with your policy. But only once every 2 years is required by the rule. So here are some of the rules relating to equipment that you should be familiar with. The title vests with the grant recipient. So what that means is that even though you get federal funds to buy a piece of equipment, you, i.e. the grantee, or it could be the sub-grantee, I suppose, if you are giving money to the sub-grantee, but you are the one who owns the equipment. So the money does not necessarily determine the ownership. The grantee owns it, even though it's with federal funds. Now, in terms of what is considered equipment as opposed to supplies, it is defined as tangible, in other words, something you can touch, non-expendable, something that doesn't just get used up, personal property, as opposed to real estate. These are all kind of code words here. It seems simple, but it's not that simple. Including exempt property charged directly to the award, having a useful life of more than 1 year, and an acquisition cost of $5,000 or more per unit. So you know, that means, for example, that a lot of the computers that you're buying these days, most of them probably are under $5,000 per unit. So that would be considered supplies now. Maybe, you know, back 15, 20 years ago when computers were more expensive, perhaps they would have been considered equipment, but now they would not, because the acquisition cost most likely was less than $5,000 per unit. The grantee is prohibited from providing the equipment to a non-federal organization for a fee that is less than a private company would charge for equivalent services unless authorized by federal statute. This has come up sometimes, let's say, with weatherization equipment. So maybe you've got all this equipment lying around, and you know, you want to say, well, let's get some money out of this here. You could do that if it doesn't. One, there are a lot of ifs. Can't interfere, obviously, with your carrying out your grant project. Another thing you can't do is you can't sort of undercharge it. It has to be basically at fair market value. So, you know, there may be for-profit companies that are leasing the same equipment. You can't charge less just because you have it funded by the government. You know, obviously this goes into sort of fair play with your for-profit business competitors as they see it. There are special rules on disposal. You need to make sure if you no longer need it for the particular project. There are all sorts of priorities in terms of, you know, can you use it for other projects that are federally funded within your agency? What do you do then? Or if you no longer need it at all, you're going to probably need to get instructions, disposition instructions from the federal funding agency, although that is potentially going to change with the super circular. That will make it easier to get rid of equipment that you no longer need without actually having to wait for written approval or written instructions from the funding source. This last one, this disclose all pre-existing debt to funding source, this really comes from a DAB decision where this was one of these community economic development grants that OCS, Office of Community Services, does. And basically this grantee had owned a bunch of equipment, but it was used as collateral for some type of financing, and that wasn't disclosed, the other financing, the other debt, and the fact that this equipment, actually I think what happened was, was that there was a clause in their loan agreement that said any equipment they buy in the future would also be subject to this lien. And so when they bought the equipment in the future with federal funds, it then subjected it to the lien, and the OCS had not known that there was even this prior debt. So they were kind of surprised when basically all this equipment sort of disappeared, even though it had been federally funded, once the bank called the loan. So again, disclosure is good, and you don't want to surprise the funding source with the equipment that was purchased with the federal funds kind of disappearing on you. Okay, so some other rules for equipment, as we talked about before, the inventory must be conducted every 2 years. So make sure you've got a system in place and someone responsible for doing that. Sometimes that's one of those things that, you know, people kind of forget about, but it is important. It is something, for example, that Head Start monitors are looking at. And here's the information. I won't read it all, but the information about what has to be tracked, what information is necessary on the inventory. There are a number of very specific things that need to be tracked and kept track of. With that, I think we are finished with the substantive portion of the webinar. Again, I want to remind you that, of course, we have a conference coming up, 2014, in New Orleans, June 18th through 20th. We are finishing a few minutes early, so if people have any additional questions or comments, we'd be happy to try to address them. If you have questions afterwards or comments, I would suggest you address them to Michael Shepsis at CapLaw, and his name and spelling of his name and so forth is on the first slide, but it is Michael.SHEP as in Peter, S as in Sam, I as in Sam, at caplaw.org. So we'll wait a minute or two to see if we have any further questions or comments.
Sure. We did have one that came in while we were talking about the equipment inventory, the requirement being every 2 years. Is that 2-year requirement grant year, federal year, or calendar year?
I'm not sure if that, I don't
We
think it says.
We can take a quick look at the rule to see if it says. I'm not sure if it does specify.
And of course, if people do have those last second questions, do go ahead and send those in.
Yeah, we'll take a look at it.
And of course, if you come up with them later,
it doesn't say. It just says a physical inventory of equipment shall be taken and the results reconciled with the equipment records at least once every 2 years. It doesn't say within what year you have to do that. So that's up to you, I think.
all right, good to know. And like I said, if there are
the guide will be out hopefully within a day or two, we hope, up on the CAP website. So do keep checking that. Certainly, probably by Monday or so, we hope it'll be up. And we look forward to your comments on that as well.
All right. We have several thank yous, but no questions that seem to be coming in. If you do come up with those later on, do let us know. You can email directly to CapLaw over to Michael. If you send them over to the partnership, we will get them routed to the correct place as well. So do not keep any questions to yourself. Let us know what we can do to help. With that, are there any closing thoughts before we finish up for the day?
I don't think so. Thanks so much for all your participation, and thank you, Cashin.
All right. Thank you. Have a good afternoon, everyone.
Bye-bye.